Item number 5. After 15th of August. Hey. Okay. This is 5. Yes. And who is Mr. There is somebody, private respondent? Okay, you have informed. Mr. L. Mohan, learned counsel appearing for learned counsel for the appellants has sought an adjournment. Full stop. As the prayer is not opposed by the MSM A. Begum, learned additional public prosecutor for the respondent number 1 state, comma, the prayer is allowed. It is submitted by Mr. Mohan that he has taken consent from the learned counsel for the respondent number 2 to make the prayer. Full stop. The appeal. The hearing of the appeal stands adjourned for 2 weeks.
May I please, Your Lordship, I beg to mention item number 1.
1. Yes.
Is out of station. Kindly
Huh?
out of station.
Who?
But
Kyle.
here- Yes, Lordship. Kindly adjourn the matter for a day.
Okay. Who is for the appellant? Anybody available? MS S. Begum, learned counsel for the appellant, and MS
M. Deka.
M. Deka, learned counsel, appearing for Mr. Asikal, learned public prosecutor, NCB, are present. Post of MS Deka, learned counsel, has submitted that Mr. Kyle, learned public prosecutor, NCB, is out of station on personal ground, and the appeal be posted after 2 weeks. Post of a circular mention memo
Yes, Lordship.
to that effect has also been circulated yesterday. Post of. Accordingly, release the case after 2 weeks. 1 day, 2 weeks by the office. 1.
Hi, Your Honor.
Okay, Mr. A. M. Dr. Lanet Amicus Curiae for the appellant has submitted that has sought listing of the appeal after 2 weeks on the ground that he is not keeping well. MS A. Begum, learned additional public prosecutor for the respondent state who is in attendance, has no objection to the said prayer. So release the appeal after 2 weeks when I get 2 weeks by the office.
Although I have not priorly requested for adjournment of regarding item 4, Lordship.
Yes.
I have received a paperwork which was in original, but there is an order of 24-23 to re-examine, to examine 2 more persons, and their statements are recorded, but those repositions were not provided to me, Lordship. If I
Something is a report of
was earlier part, but then some direction was there, 24-23 already there. And those repositions are not provided.
28. LCR था? LCR.
No, deposition has been taken, Lordship.
28 for 2023. Yeah, visual sound. Yeah, visual sound. Bharat Miss B. Sharma, learned. And Michael Scurry for the appellant. And Mr. K.K. Das, learned additional public prosecutor for the respondent state. Postal. This court as an appellate court, on 28/04/2023, directed Learned Sessions Judge, Baksa, Musalpur, to examine two more witnesses, and thereafter, to forward the evidence of the said two witnesses to this court. Court's law. As per office note dated 25/7/2024, the learned session judge, Baksa Musarpur, has forwarded the evidence, the records, the case records of sessions case number 52, stroke 2018, along with the testimonies of the two witnesses, as directed by the order dated 28/4/2023, after examining them as CW1 and CW2. The learned counsel for the parties have submitted that they are not provided with the copies of the testimonies of CW1 and CW2. And have submitted that they may be provided with the copies of the testimonies of CW1 and CW2. Full stop. As the request of learned counsel for the parties appears proper, the office to furnish copies of the testimonies of CW1 and CW2 to both MS Sharma, learned amicus curiae for the appellant, and Mr. Das, learned additional public prosecutor within a period of 1 week from today. Stop. List is appeal after 2 weeks on a date to weeks by the office.
Hearing item number 3. Beleg. Yes. Offense. Video. Sessions case number page 32. Page 51. RI for life and 1000. One of them were
What?
PW4 was the sole eyewitness
However, his witness evidence was rejected. And therefore, the entire case of paper. When it is that paragraph on the
Paragraph 23.
page 40. Now, coming on the role of the from the evidence that in every case, it appears that no PW code is relevant to force that upon hearing given by or the basis regarding he along with other family members came out and saw interest running out of their place of preference on which it chased in and brought their day upon his return. Taking again physically assaulted dramatically on our day and on his attention, he was also intimidated by the on this scene along with some type. This part of the evidence of PW4, however, not supported by PW wanted to pay. Who have arrived at the scene of conference along with PW. Moreover, this part of the evidence was secondary. As PW4 has not stated the change before the police regarding the maximum bringing him back, saw the increase in assaulting the deceased paper. So under the circumstances, this part of the evidence was not considered as admissible evidence, which otherwise cannot be relied. Then certainly there is no argument in this case, and for the reason takes place not the
Yes.
That's the that is like at their efficiency. You want to vote or not? There is a separate. Currently,
Yes.
each 9,000. Humble submission is that around 10 PM on 7/9/2014, my number was Amanda Laxmi contribution with the part of some family and follow for the he put on cake some 3 or 4 times. Meter range. As a result of which he sustained various immediately with the line of police by evaluation and provided as a commission team was serious. We got the definition to the government was that's why they arrived to government. But around 4 AM, they succumbed to her. Therefore, it is made that it's been more than if I was government, I would at least under section 302 was registered. That conveying yes.
Mic to heavy kona. Mic to more galne.
It was switched off, my lord. It was switched off.
Huh?
It was switched off, the mic. If I'm audible now. So the FIR was lost by my elder brother. He is PW1, my lord. And then Howlating PS case number 145/2014 under section 302 was registered, my lord, on the basis of this FIR. On the same day, 8/9/2014, I was arrested. And since then, I'm in jail, my lord, for the last 9 years, 10 months, 23 days. Now, the case was investigated, the charge sheet was filed, and thereafter the charge was framed, my lord. The charge is at page 6. Only one charge, that on 7/9/2014 at page 4, page 6, my lord, at about 10 p.m., you have committed murder by causing the death of Srimati Revati Lahan and thereby committed an offense punishable under section 302 of the IPC within my cognizance.
No, I'll share this. Yes,
If I may place the evidences, my lord.
no, charge has been reframed. Is it not?
I may have missed that, my lord. I didn't get it. And 51/2018, my lord. That on 7/9/2014, at page 7, it was reframed. You have physically assaulted your wife. That on 7/9/2014 at about 10 p.m. you
1
have-
minute.
My lord.
PWK, last PWK criteria examination. Three friends, everything. Because of D1 2018. Saves you some? Two 32. Yes. There was alteration of charge.
Alteration charge after the hearing was concluded, and this can be done under section 216 matter. At any time before the judgment is passed. And in fact, under section 212, it has been made more specific as to when the incident took place and when she died.
So you showed disinclination to recall the witnesses.
Hmm.
That is recorded. Yes.
PW1 matter. Page 9. Is Selin Lahon. He says that the accused is my brother. Deceased Reboti Lahon was the wife of the accused. Reboti Lahon died about 1 year ago. On the day of occurrence, while I was at home, I heard a commotion in the accused house, which is adjacent to the that of ours. Whereupon I came out and saw Reboti Lahon lying at the doorway to the accused house. The accused was there with an iron rod-like weapon in his hand. When I went to the place of occurrence, my father, Ananda Lahon, also reached there. Ananda Lahon is PW4 madam. Flashing torch, we found the accused holding the rod. Seeing bleeding injuries of Reboti Lahon, we called 108 ambulance service and took her to Amguri Hospital first, and then we took her to Jorhat Medical College Hospital. Reboti died at about 6 a.m. on that day. The VDP secretary was informed over phone, whereupon police came and arrested the accused. The police seized the rod used in the occurrence and obtained my signature. In the seizure list, Exhibit 2 is the seizure list and so and so. Material Exhibit 1 is the rod, which I have seen in the court today. I lodged the Azahar on the following day of the occurrence. Exhibit 1 is the Azahar. One Nasiruddin Ahmed wrote the Azahar as per my version, and I have recognized Exhibit 1-2, the signature of Nasiruddin Ahmed. The rod was seized by police on being shown by the accused. Exhibit 2-2 is the signature of the accused, Mahendra Lahon, which I am familiar with. Police examining me. In cross, he says that I did not see how the incident took place. Iron and steel are two different metals. Police seized Material Exhibit 1, the iron rod, from the accused house, not from his hand. It is not a fact that I have not stated before the police that the accused had shown the rod to the police and that I have adduced false evidence. So he is not an eyewitness. He did not see the incident taking place, madam. And he says that the weapon that was used was an iron rod. Whereas the exhibit scissor list, madam. Exhibit 2, it talks about a steel rod. Page 54.
It says it is steel rod.
A meter handle yardstick, steel color with
Steel
red
color.
cap on so and so.
Not steel rod.
$70. At page 79, if you will see for a moment. The rod was sent to the FSL for examination. And they say one metallic handle steel stick, length about 2 feet.
What benefit will be derived?
He has recognized the stick was shown in the court. Otherwise, he has,
Everywhere, it is not a rod simpliciter or steel rod simpliciter. It is a wrench like something or meter handle. I don't think it is a plain one.
but in his
It is difficult to describe.
difficult to describe.
It is not a
wrench,
plain rod
2 feet.
which is used in construction, 16 mm or 24 mm, or it is something part of a instrument perhaps. Meter handle, somebody says wrench. It is difficult to describe properly.
Right.
Okay, but
Peter.
it is made of solid.
solid thing. PW2,
Any discrepancy in the description, in other description like 2 feet, 5 feet?
no
No.
size, nobody has said anything.
Did you confront on that matter that it is of 5 feet length, 2 feet length?
No, madam.
What was the seizure list otherwise? Seizure list 54. 54.
54.
Red cave in one, and then the other end is slightly broad by 9
by 9
inches.
inch.
Length is about 2 feet. One end is
Encryption is the torque
Hello.
master.
কোনোবাই ৰেঞ্জ কৰিছে, কোনোবাই মিটাৰ হেণ্ডেল কৈছে, কোনোবাই আকৌ কিবা বেলেগ কৈছে, মেটেলিক হেণ্ডেল. It is not simplicity, but 79 also says 2 feet.
2 feet.
Both says 2 feet, seizure list and
FSL.
the FSL report. Maybe the description was not proper. When Mr. Prasad describes a particular thing, if it is not simplicity or rod, you will describe in another manner, MS Bhuya will describe in another manner. But whether anything substantial or material, you could derive out of it. That is a material thing.
PW2, madam.
Somebody says steel color, somebody says
Yes.
steel rod,
Steel
somebody.
rod. Iron rod.
So steel is made of iron. Is it
Maybe
not?
a different component, madam.
Hmm? It is a, what do you say? Amalgamation
Amalgamation
of
other
two metals.
metals.
One is iron.
Because steel doesn't have rust.
So one is iron and other will
Pure.
be aluminium and something. After
Actually-
amalgamation, steel is
Produced.
produced. But that is what Tata Iron and Steel Company. First
You manufacture
iron,
both.
thereafter steel. So steel is made out of iron. Yes.
PW2, my lord. Page 11. She is
Page
the wife,
11,
wife of PW1, my lord.
wife of PW1, sister-in-law.
My sister-in-law.
Yes.
She says, I know the accused. This is Rebati Lahan was the wife of the accused. In the night of 7/9/14, while I was at home, I heard a commotion in the accused house, which is adjacent to that of our house. Whereupon I came out and saw Rebati Lahan lying injured in the courtyard of the accused house. I saw an iron rod in the accused hand. Police came and arrested the accused. Rebati Lahan was taken to Jorhat Medical College Hospital, where she died. Police seized the rod. Exhibit 2 is the seizure list and my signature. Material Exhibit 1 is of steel color, which I have seen in the court. Police examined me. I gave my statement, which is Exhibit 3 is my statement before the police. I saw bleeding injuries in Rebati's head. In cross, he says, I did not see how the occurrence had taken place. It was dark at the time of occurrence. It is not a fact that in my statement to police and court, I did not state that I had seen an iron rod in the accused's hand at the time of occurrence. It is not a fact that in order to grab the accused's share of property, my husband and I have adduced false evidence in the court.
So it was only a suggestion, first
Only a
part,
position.
that she did
The
not make
allegations made by her.
such statement. And second part is suggestion and a defense plea. Okay,
Because 1, 2, 3, and 4 are my family members. My
3,
3 is my mother, my lord.
okay.
Shenima Lahan, PW3, page 30. She says, the accused is my son. This is Rebati Lahan was my daughter-in-law and the wife of the accused. They lived in separate house, which is adjacent to that of ours. Around 10:30 PM on one day, about 2 years ago, while my husband and son, Selin Lahan, daughter-in-law, Selin's wife, and I were sleeping, we heard a cry, "Hi, Morigulu." Whereupon we came out of the house and saw Reboti Lahon lying injured outside the accused house and the accused moving there with a rod in his hand. Seeing us, the accused pelted stone at us. Then my husband and son Selin caught hold of the accused and tied him up. The villagers gathered there. Reboti was taken to the Jorhat Medical in a vehicle. I saw injuries in the Reboti's head. Around 2:30 a.m., Reboti died at Jorhat Medical. Police came and examined me. Police seized the iron rod found in the accused's hand and obtained my signature. I've seen material exhibit 1, the said iron rod in the court today. I gave my statement in the court. Exhibit 4 is the said statement. I had not seen the accused assaulting Reboti. The accused is my youngest son. Since 5 years back, he started living separately. I do not know whether accused committed the incident with the material exhibit 1, the iron rod. Nobody told me that Reboti was assaulted with that iron rod. So everybody came after the incident had already taken place. When they came, they saw an iron rod in my hand and my wife was bleeding on her head.
But you did not contest in any manner regarding your presence.
No.
So everybody said immediately
That's it.
after the hue and cry, they from the adjacent houses
They came out,
reached the
my
place
place
of occurrence, found your wife lying
bleeding
injured, bleeding at the doorstep, and with you,
with
with
a rod
an
in my hand,
iron like rod or whatever,
in my hand.
standing nearby. This is the situation.
The only plea that I have taken,
All three.
all three, all four even.
Let us see four.
Four is my father, my lord. And his evidence has been rejected, being the eyewitness, my lord. He says, the accused is my son. This is Reboti Lahon was the wife of the accused. Since 5 years ago, the accused started living in a separate house, which is adjacent to that of ours. Around 10:30 p.m. one day, about 2 years ago, while my wife, son Selin Lahon and I were sleeping, we heard a cry, Murilu. Whereupon we came out of the house and saw Reboti lying injured outside the accused house. When the accused tried to run away from the place, this part has been rejected, man. Tried to run away from the place of occurrence. I chased him. The accused then again came to the place of occurrence and again assaulted Reboti with an iron rod. When I prevented him from doing so, he threatened me and so I moved away. After that, my son Selin and I caught the accused and tied him up. Though we took Reboti to Jorhat Medical by vehicle at 2:30 a.m., she died there. Police examined me. I gave my statement in the court. Exhibit 5 is the said statement. Police prepared the inquest report and obtained my signature there. Exhibit 6 is the inquest report, and so is my signature. Material exhibit, the said rod used in the occurrence, which I have seen in the court. It is not a fact that I did not in processes. It is not a fact that I did not state before the police that when the accused tried to run away from the place of occurrence, I chased after him, and then the accused came again to the place of occurrence and again assaulted Reboti with an iron rod, and that he had threatened me. I had handed over the seized iron rod to police. The accused started living separately after quarreling with me. I lived in our original old house with my elder son. I did not like the accused for his quarrelsome nature. It is not a fact that since I dislike the accused, I have adduced false evidence.
So this part which that trial court has
That I was-
said
I didn't-
that there was embellishment on the part, improvement on the part of PW4. That has not come as a contradiction.
But that was not supported by the other witnesses.
There is a contradiction. Appears to be an embellishment. Where the trial court has held that observation?
Paragraph 23, my lord,
23,
page 43.
page 43.
last two lines. This part of the evidence of PW4, however, was not supported by
appears
PW.
to be exaggerated. It should be stopped there. The other part is unnecessary because court cannot look into 161 statement unless it is used for contradiction. As PW4 has not stated the same before the police regarding chasing of accused, bringing back the accused, saw the accused in assaulting disease, rebutted. This cannot be
Taken into
included
consideration.
in the judgment because the defense has not confronted PW4 with his previous statement and thereafter brought the contradiction by extracting it from the IO. So this part is gone. You cannot comment on it as PW has not stated before police. This is wrong. This part is a embellishment. That part is not consistent. Chasing,
Chasing and again coming back and again hitting.
coming, bringing back, assaulting. This part is not consistent with the testimony of the other three witnesses. But so far the next comment is concerned, that cannot be made.
Because the first part of the incident which happened, nobody has seen.
Yes,
This is an additional then
this is an embellishment because his son is involved. As a parent, I had handed over the seized dog or seized iron rod to police. What about this evidence? Let us see the iron rod once again.
No.
Who said iron rod? Police seized the rod used PW1.
this is from
Seized
the
the
position.
rod used in the occurrence and obtained my signature in seizure list. Okay.
But in the seizure list, it says it has been
One by one, let us see one PW2. Police seized the rod. They simply said that police seized
has
the
said that.
rod. They did not say anything further, PW1 and PW2.
PW2, page 11, fourth line. I saw an iron rod in the accused hand.
No, seeing is one thing,
Yes. Seizing
Seizure.
is-
seizure is, I am just finding out. PW1 says simply that
that the
police
material
seized
exhibit
the
was seized.
rod used in the occurrence. Then PW2 said police seized the rod. PW3
Police seized the iron rod found in the accused hand and obtained my signature. But
Mhm.
from him, it is not being stated.
it is not said.
Says that the rod
He
which was in the hand of
identified the
the
seized rod to be the rod in the hands of the
accused.
accused. And PW4 is saying somewhat differently.
No.
Right?
No.
What he said?
He said
I
he
don't-
has handed over.
Huh?
He has handed over.
কোনখিনিতে ক'লে?
In the cross
Ah,
line. I had handed over the seized iron rod to the police.
and you objected for what? Huh? So you objected. Now where is the seizure list once again?
Seizure 54.
From the possession of accused. Did you put any suggestion? No. Red cap. Soilan Purobi Senihai. Prabhat. Prabhat? Prabhat of PW5. This part is contrary to the seizure list. I handed over. He was not a witness also,
I'm not a witness.
seizure witness. Was he a seizure witness? No,
Silent Purabir Chinimai, no more.
I don't think he is a seizure witness.
No problem.
Anando.
He's not there.
Soilan Lahori is PW one,
PW one, Purabir is PW two,
PW two,
Cinema is PW three,
Senime PW
three, my mother,
three, and the next one is PW five.
Prabhat. Wait. Yes, PW
He
five,
is PW five.
PW five.
This man was not a witness to the seizure. So
Three witnesses.
there were two improvements. One is that
Second incident,
changing,
running away, coming back again.
coming back and assaulted
And handing
the
over of the-
deceased by the accused again. That part. Then I handed over the seizure to police. Yes.
PW five, ma'am. Page 17, PW five, Prabhat Gogoi. He is the Sarkari Gaonpura. He says, I know the accused. This is Rebati Lahon was the wife of the accused. The occurrence took place 2 years ago, around 7:38 p.m. on that day, hearing commotion towards the house of the accused, which is adjacent to that of ours. I went there and saw Rebati Lahon lying on the courtyard of the accused in a moribund state with bleeding injuries in her head. Being the government Gaonpura, I informed the police. The accused was kept tied by the members of his family on the courtyard. Police came and arrested the accused. I was kept tied. There was no opportunity for me to hand over the iron rod to the policeman.
Yes.
We took Reboti to the hospital. The members of the family of the accused showed us an iron handle and told us the accused had assaulted Reboti with that handle. Police seized the handle in my presence. Exhibit 2 is the scissor list, and so is my signature. Material exhibit is the said handle used in the occurrence. In cross, I had not witnessed the incident. I did not state to police that going to the place of occurrence, I saw Rebati Lahon lying on the courtyard of the accused house with injuries in her head, and that I had informed the police of the occurrence. I had not seen the accused assaulting Rebati with the seized iron handle. All these 5 witnesses, they reached the place of occurrence immediately.
Almost immediately.
Almost immediately. So that second.
There
part
is
of the
very
incident-
less time gap.
Very less,
Sketch map indicates
very near about,
distance is very.
very. And that's how the evidence of PW4 that he had
Yes.
improved his evidence was not acceptable. There were 2 injuries, my lord. That will be by PW6, my lord, if I may
Hmm.
please take PW6. Page 19. The postmortem report, exhibit 7.
Was the dislocations calculated by present spinal cord. Lesser discal deep cortex of alternative this. 4 to 8 hours. Where is the PM report?
My lord, page 70. Exhibit 7. Examination was done around 12:30 PM on the same day. Early in the morning, she died. And 12:30 PM, it was done.
8 hours.
8 hours. The injuries are page 72.
So
Rigor mortis
early hours in the morning.
in the morning, 2:30 in the morning.
Somebody says 2:30,
2:30,
somebody says 5, somebody says 4. But as she died in the hospital,
Jorhat Medical College. While being taken or
Mm.
when reaching.
and it is clear as per the opinion.
Right.
Injury number 1, sufficient to cause death of a person in ordinary course of nature.
Right.
So thirdly will come. Thirdly, section 300, ordinary course of nature.
She's died in the hospital.
Thirdly,
Third, 300.
culpable homicide amounting to murder and culpable homicide not amounting to murder. What is the word? Sufficient to cause death in the ordinary course of nature.
Nature.
If intention is there, it is murder. If intention is not there, it is culpable homicide not amounting. to-
One of the factors your lordship will take into account whether the accused person took undue advantage.
No, if
In order
the
to bring it
intention,
under general exception.
how this will come? Nothing was there
Well, nothing, in this
to,
case. it's
to,
not-
to bring any exception for the accused. Suppose
In order to.
this
grant
death
the
is
benefit,
connected to
madam.
the accused,
My lord.
then the issue is this part. Fatal injury is sufficient to cause death of a person in ordinary course of nature. Next one is homicidal in nature. And the injury is sufficient, blunt weapon, head,
Vital part.
Vital part.
so one or many. Unless the accused is successful in bringing any of the exceptions into
Right.
operation, it will be treated as culpable homicide amounting to murder coming within clause thirdly. And we have to remember Bhisa Singh, Justice Vivian Bose.
I'll be relying on.
That Vivian Bose is clear,
Clear.
and that has stood the test of time.
Lordship.
Yes. Let us see what kind of submission Mr. Prasad will make. PW7.
PW7, my lord. His neighbor. Is Badrudul Islam Laskar. He says, accused Mahendra Lahan is known to me being next door neighbor on 7/9/2014. Well, I was working as Imam of Halating Masjid at about 8:30 PM on hearing hue and cry at the residence of Mahendra Lahan. I went to his residence and saw his wife was lying in injured condition with bleeding injuries on one side of the courtyard. Accused Mahendra was kept apprehended by the local public. By this time, wife of Mahendra was taken by ambulance for treatment. After some time, police took Mahendra Lahan. On the next day, I heard that the wife of Mahendra Lahan had died on her way to the hospital. I have heard from the gathering that accused Mahendra Lahan has assaulted his wife. In cross, it says, I cannot say why accused Mahendra Lahan was kept confined at that time. It is not a fact that I have not visited the residence of Mahendra Lahan and did not see the wife in injured condition.
Come to page 79. Whereby this B exhibit was seized.
B is some amount of soil.
Soil,
Which
1
was
gram,
They say it was with
by
the-
which seizure memo the IO had seized, and from which place?
Not
Soil mixed with blood. Huh? Okay. Blood, soil. No. Very correct. I have sent. I have sent. No, I have seized. Where is that? Yes, Ms. Bhuiyan. Page 79. Okay, this so-called iron meter handle, whatever. It contained blood stains that was deposed by witnesses, right? Seizure list also mentioned about it. So that metallic handle or whatever, iron, 2 feet length was sent for serological test. Now that was matched with the blood group
No.
extracted from. Please see result of examination. Please see 79. The result that the blood group of the blood found in the blood stain in the iron
Iron rod.
meter was found matched with the blood group found in the
soil. Mixed with
soil mixed with blood. Both were AB. Now my query is by which seizure this exhibit B soil was collected to provide a link because see page 20, autopsy doctor says, in my report, I have not mentioned the blood group of the disease since PW6. PW6 means who?
he himself.
He himself
It's
was
only-
not asked to examine the blood group of the disease. Sometimes the autopsy doctor was asked to, IO used to ask, please give me a boil or whatever this blood group of the disease. And after collecting it, IO sends it for serological test so that the blood group
in the
of
weapon
the disease
and the
can be
weapon.
matched with blood stains found somewhere, weapon of assault, at the place of occurrence, or on the bed, or on the soil. Now here you match the blood group found in the iron handle with the blood group of the blood found in a mixed soil, 1 gram. 1 gram is 1 gram. Where from this 1 gram? Huh?
Nothing is on record.
Nothing is on record. That is not providing any link.
Right.
Soil কি কাম করবো?
That is
Along with
Blood mixed soil to FSA.
Provide no কৰিব না এইবোৰ link.
iron rod in the scissor list. It's exhibited.
AB is
So B
okay,
is a-
quite,
So B
okay,
is a
quite all
different-
right, blood
B
group,
is different.
but
Grouping is not done.
grouping of the diseased blood
Yes.
group, that is not confirmed,
That is also not.
not confirmed. Yes. The deposed initial could be in the directive, I have appeared, the GD entry. GD entry. GD entry. GD entry. You will do the GD entry book. 140. And you're doing the one. Where is the GD entry?
Page 87.
Page 87. Nothing, 15. Yes. One, two, three, four, five. Batrul Islam, law score 21. 21, including one. What is the defense?
Now, no motive has been stated here.
Now, did you owe any explanation? Because 313 you said question number 2
Right.
that you used to live
Together.
with your wife in a different house near to the house of PW3 and PW4, which are your parents.
Right.
Admitted.
Admit.
They said immediately after the occurrence, they reached the place of occurrence, found the wife lying
Lying, bloody
injured or whatever, lying injured at the doorstep, with you standing nearby,
with an iron rod. It not-
with an iron rod or meter handle, whatever, there. So immediately after occurrence, you were there. The fact that you used to live with your wife in a separate house, that is also not
Admitted.
denied.
In fact, it is admitted.
So in such situation, only plea which appears to have been raised by you is that you are not very, your relationship is not very well with your parents or your elder brother. But you used to reside in the same compound
In a
for
separate
last
house.
5 years separately. So that was a suggestion without any
For the proof.
further proof
or corroboration.
by preponderance of probability also to say, discharge the honors that there was some kind of enmity. Mere separation from your parents or your brother and living separately would not give that they will be implicating you for death. You have not attributed any act on their part, culpable act. Not
Anything that
contested.
I've not stated anything about the incident. I say after the incident,
Hmm.
I was beaten up by my father and my brother, and I was tied up.
What did you say?
313 statement, question number 47.
Subsequent.
Huh?
Subsequent that I have stated, page 30.
Let us see, please.
30.
Page 30 last answer.
Page question number 33.
Last question 47.
Yes, after seeing you standing with a stick at the place of occurrence, they have said, we have apprehended him.
Lordship will grant me 2 minutes time.
We have apprehended him. They have clearly said. In the process, maybe some assault. You are not clear that
They had
this goes consistent with the testimony of your brother and father. That my father and brother physically assaulted. They have said we have apprehended.
apprehended.
If there is resistance, there will be some assault also. I cannot say what happened thereafter. I don't know. On getting sense at AMCH,
Apart from this, I have not
Please
taken any.
bring to our notice something that he lost consciousness
That's what he says.
because
that-
independent witnesses, I think PW5 was independent witness. Is it not? He's a Gambura. Accused was kept tied,
By the family members,
right?
as well as.
He did
IO.
not say that you were senseless. And PW7 also.
PW8 also
PW7, then in the IO,
was kept
at
apprehended
the
by
place of
local public.
occurrence,
Hmm.
accused Mohinder Lahan
Was kept apprehended by the local.
and some injury marks seen on the accused. He also said,
Even the.
Now what-
eyewitnesses.
benefit you can derive from it. PW, your brother and your
Father.
father. Your brother says what?
PW1.
The accused.
He doesn't say anything about apprehending me.
Grabbing. PW3 says, paragraph page 14.
14. Then my husband and my son, Selen, caught hold of the accused and tied him up. Similar is PW4, page 16, third line.
Hmm.
After that, my son, Selen, and I caught the accused and tied him up.
There could be active help from
Possibly.
neighboring people also.
Because
People gathered there in the meantime. So you were outnumbered. So in the process of grieving, maybe. And IO has said also,
I was also saying,
you had injuries.
I had injuries and I was taken to the hospital and
Huh.
given preliminary treatment.
Treatment, so senselessness is
Page 23.
not an explanation. Appears to be false explanation.
The evidence, even if accepted, my lord,
Huh.
it is in continuation, my lord. It is in continuation. It may not help me for proving my, rejecting my accusation.
Even that
Which means-
matching of blood group is discarded also. But PW1 to PW4 were consistent except that one embellishment.
That
That
apart,
embellishment is only embellishment, but because the other part, you did not confront him with
I didn't
his previous statement.
no,
So trial court cannot use the police statement to make such observation. So only thing is that some embellishment on your part. That PW4 part.
No.
Treatment, medical statement.
Mhm.
Medical treatment. Medical treatment.
in fact, PW4 had
Alright.
exhibited that 164 statement himself.
1 minute. Some blood mixed soil have been seized from the PO.
But Caesar memo is not there.
When the additional superintendent of police forwarded these exhibits, he had written it properly. But IO did not.
To prove that it was taken from the place of occurrence. That had to be produced.
Really, some soil with blood mixed. That was usually accepted. IO also seized meter handle having blood stains and some blood mixed soil. So the blood mixed soil is something else.
Something else.
Superior officers had written it properly, but yes. December. Examination was celebration. Examination. Key explanation is it? Key explanation is it? Key explanation is it? Who says a code?
Laurishi, 164 statement of PW3, it was recorded on 4/9.
Or
4/9, I don't know, some mistake may be there. At
cannot be
page
4/9,
59,
cannot be 4/9 by any means.
oh,
18 or 20.
it's very bad. Before
Date
that,
of occurrence?
Date of occurrence,
Incident 7/9, no, no.
8.
FI is on 8/9, incident 7/9,
Side.
output 3/4.
The signature says,
Hmm? Cinda,
original.
দুটাই আনন্দ লাগানোর উপর
Actually, English লিখেছে যে আমাদের ওখানে ধরে কোনো translation হয়।
Eleven nine. 11/9.
চেনিমাই লাগানো
আনন্দ লাহন, সেনিমাই লাহন, পার্বতী লাহন।
page 59,
Correct.
Wrongly typed.
59.
page 59 as well as page 60.
59. 59. It should be
11.
11/9. It should be 11/9. Page 59. And 62. Both should be 11/9. Mr. Prasad, when he was produced, remanded, before remanding to custody on 8/9, IO made a prayer for, made a prayer by an application to record a confessional statement of the accused. Then reflection time was given by the magistrate. After remanding him to jail to make confessional statements, directed to produce on the next date. But on the next date, you also explained to the accused. So you are in your senses. On the next day, you fell sick. On 9. So superintendent was asked to produce the accused after accused recovered from illness. It was on 10th. It was suggested that you should be sent to Dibrugarh Medical College for treatment. So 2 days you were in senses, you were in jail. Regarding 164, object and purpose and provisions of 164 was explained to you by the magistrate.
Detection
Then
time was granted to me.
You were asked to have a reflection. Then on the next day you fell sick. Then on 10th of September,
I was sent for
it
treatment
was suggested that you should be sent for
for the
better
treatment.
medical treatment to AMCH. So question of regaining such senses in AMCH does not arise. In the meantime, you were explained 164, purpose of 164.
That was prior, madam.
Yes, prior.
No.
So
my-
this
my coming-
313,
My coming into senses in the AMC.
some you were on 8, 9 itself.
8-9 itself,
You were before the magistrate.
later part.
Which part?
Because PW 8 says I was immediately arrested and taken to the hospital for treatment.
I have not
say-
seen it. I have seen everything.
Well-
That is why I have seen everything. I have gone through. Tell us any AMCH, you were taken to AMCH.
I did not
AMCH.
say,
He is very specific.
in
At
47
AMCH,
Yes,
you regain sense
at AMC.
AMCH. But from 8-9 to 10-9, you were not in AMCH. You were pondering over whether to do it or not to do it. Then you fell sick. Show us that you were given treatment for some serious, some kind of abrasion or something might happen, but we don't think you have lost senses on 8-9.
After the.
Nothing has come out. At the fag end of the trial, perhaps it has been advised. Yes. Anything more?
My lord, it is a fact that I was taken to the hospital, not AMC, but Amguri CHC, as is written in the forwarding letter also, as well as the evidence of PW8, the IO matter. I was apprehended. I was taken to a hospital, I put sense.
That was part of a natural reaction on the part of the.
But my condition that deteriorated, the request that was made before the judicial magistrate, that I should be sent to a hospital for treatment and hospitalization,
That is post occurrence.
post occurrence.
So what we are concerned with,
And prior occurrence, I have not given any explanation.
the
It's not
circumstances
there.
preceding the occurrence and attending the occurrence. Those are post occurrence events.
Post occurrence.
It has not emerged from your any defense that you were injured. At the time, you were seen wielding a
I don't,
iron rod of 2 feet length with your wife
I have not,
lying injured by your side.
I have not disputed that.
So that evidence is clinching so far as that is not
No,
shaken in
Right.
any manner. So though it is not a case of direct evidence of assault, so
Yes,
what
sir.
principle will come?
circumstantial evidence. The entire chain has to be proved.
Now, this is immediately after occurrence. What principle?
106.
106.
I have to explain. I have to explain.
Yes, 106. Evidence Act. Evidence Act. So,
Burden of proof, especially within the knowledge.
So all these circumstances lead to one situation that you are the probable assailant. Now,
Understood.
what explanation you have offered, that is material. Now, the explanation you have given in 313 is regards
Post incident.
but your 313 question number 1 and 2, you admitted that you used to
Reside
live
with the
together
victim.
with your wife in a separate house. Usually 1 to 4. From their evidence and the distance of the houses they used to live, their presence immediately after hearing the cry of the wife was natural. So, and it was not contested in any manner that by you that you were not present. Willing
I don't know.
simultaneously, your wife was found
Lying on the
lying
floor.
on the floor at the doorstep of your house, and you were standing there with a
Right, I have not.
iron rod or steel rod or whatever. So you owe an explanation. Under 106. Yes, anything in support of such
I'd like to
situation?
place one judgment. Fine.
Trimukh is one,
I have latest one, AR 2024 SC 2297. And it's-
Padiwala, Justice
Yes,
Padiwala,
yes, sir.
Balveer,
Ennis.
Ennis,
State
Ennis.
Government and City.
Papu Bhai. Going by the head note 1, A.
Right.
However, in an instant case, since other circumstances in chain are not
Not
established, but we are dealing with a case, it is clear that the wife met a homicidal death. Post occurrence, whether the principle of res judicia will come. Res judicia will come, I think. What is the principle of res
Section
judicia?
8 of the evidence. Section 6. No? Facts which though not in issue are so connected with a fact in issue as to form part of the same transaction. Are relevant whether they occurred at the same time and place or at different times and places.
Fifteen is quotation of Birdichan, Sharad Birdichan.
Sharad Bidichan.
Sixteen, if I may please. Further, the mere suspicion would not be sufficient unless circumstantial evidence tendered by the prosecution leads to the conclusion that it must be true and not may be true. In that regard, it is necessary to take note of the decisions in so and so, wherein the court, on noting the decision of Sharad Birdichan, has held. I'm reading that part now. Paragraph 17. It has further been considered by this court in so and so. It has been propounded that while scrutinizing the circumstantial evidence, a court has to evaluate it to ensure the chain of events is established clearly and completely to rule out any reasonable likelihood of innocence of the accused. The underlying principle is whether the chain is complete or not. Indeed, it would depend on the facts of each case emanating from the evidence, and there cannot be a straitjacket formula which can be laid down for that purpose. But the circumstances adduced, when considered collectively, it must lead only to the conclusion that there cannot be a person other than the accused who alone is the perpetrator of the crime alleged, and circumstances must establish the conclusive nature consistent with the hypothesis of the guilt of the accused. On an analysis of overall fact situation in the instant case and considering the chain of circumstantial evidence relied upon by the prosecution and noticed by the High Court in the impugned judgment, to prove the charge is visibly incomplete and incoherent to permit conviction of the appellant. They have alleged that I was holding that rod. They have sent the rod to the FSL, but they have not cross-checked whether it was actually in my hand. The fingerprints have not been cross-checked. The blood in the iron rod has not been meshed with the victim. Whether that rod actually had been used to cause that injury. And 21, Manu, paragraph 21. The High Court holding the appellant guilty of pouring kerosene around the deceased and her children and setting them on fire, since the appellant had failed to explain the reason for the eruption of fire in view of such obligation to explain under section 106 is also not sustainable in the present circumstances. As held in Sarad Vedation, the failure to explain can only be held as an additional link to complete the chain of circumstances. In the instant case, since the other circumstances in the chain are not established, the same cannot be held against the appellant. On the other hand, the case itself is that the fire had erupted so and so.
Now let us see the facts of this case.
Right. Paragraph 2. The appellant was charged with the offense of as accused, while her husband and his mother of the appellant were charged as accused number 2 and 3. So and so. The case of the prosecution is that Gulab, son of so and so, was married to the deceased. Paragraph 3. 2021. 1 week. Yes, yes, sir. Effective.
There were many inmates when the fire broke out. An explanation was provided, one observation was made that if in the middle of the night, for whatever reason, there was fire, and if the appellant had woken up and noticed it a little earlier, the natural conduct is to run out of the house instead of going into the house which is burning to check on the other inmates. It takes a person a lot of courage or be overridden with compassion to get back into the house to save somebody else, and not doing so may be considered morally wrong for not coming to the aid of the fellow human being in distress. But it cannot be a circumstance to hold a person guilty of crime which is serious as murder unless the circumstance of the same points towards the accused so as to lead to a irresistible conclusion of being guilty. So there were your husband's first wife was there, her two children were there, your father-in-law were there, your husband was not there, your mother-in-law was not there. So suddenly in night, fire
Fire.
erupted. You ran out of the house. Noticing the fire
Fire.
at first point of time, instead of saving your
Other
husband's
units.
first wife, you being the second wife, or her
Children.
children, minor children. But father-in-law, noticing that there was fire, he tried to rescue
One of them.
the first wife of your husband and the daughter. The minor son got burned in the process and shifted. It was in such situation this owing of explanation was considered. You cannot fit it everywhere. This is not the case which fits the present case. There you may not owe an explanation. Here we have seen the circumstances. And after Sarda, I think that has been bit explained in
Various decisions.
Trimukh also. The prosecution is required to prove those circumstances which are possible to be proved by the prosecution.
So they had the iron rod, they could have taken my fingerprints. matched
Yes,
with them.
that is one
Then
defect.
The blood,
That is one defect. Notwithstanding that defect, the fact that you were wielding the iron rod, that was not disputed. And such kind of iron rod with force, if
impact,
hit on the vital part of the body like head, it is bound to
we can presume
result in
that has not been-
fatalities.
that has not been taken out by any
Now,
other evidence. It
you
can be
were-
presumed. Well,
You yourself admitted that you used to live in the house
Right.
with your wife. One part. By your explanation, PWs have said you used to live separately from in a separate house within the same
Last 5
compound
years.
since last 5 years. And that has been admitted by you in 313.
Right.
So everything got reinforced, that situation. Second is immediately after, without any time gap. They heard, they
They
went,
came,
they
saw.
found lying injured your wife and with you wielding an iron rod. That is not contested. So your presence inside the house was there. Wielding a rod is there. If a rod or steel of 2 feet hit on the head, it could result in death. And that appears to be consistent with the medical evidence.
Right.
Yes, had this
Additional evidence
been
that
proved, this serological test, with with even a seizure list, that is the end of the matter.
then I.
That could have been.
the chain
There
would
was
have-
no requirement of 106.
Right.
Right, chain would have been complete.
Complete.
That gap, notwithstanding gap, that gap, you required an explanation.
That I have not given.
That which you did not.
Or
Where is
failed.
Anis? You say? Yes, here 2029.
Para 36, 43, 44, 45, 47. And regarding the conduct also, Your Lordship. Excuse me.
Discovery.
Yeah, the problem to be for SC, W297. W297.
Remove. Tulsida. Som group 106. Bolby. Rule. Bolby. Principle of law. Governing. Strictly 106. Retail Justice Party wala. May 3. May 3. October. May 3, 2024. No, exactly, it is a principle of law governing the applicable to section 106 of the evidence. Okay, offer.
I'm relying
no,
on AI
one
online,
minute.
my lord.
Para 35 to, that is 106 discussion,
35,
to up to para 48. The
Lordship.
discussion on 106,
My lord,
right?
my lord,
There is a prior decision,
my lord.
Balbir Singh versus state of
Yes, Uttarakhand.
Uttarakhand.
Yes,
It is mentioned there.
my lord.
Which paragraph?
Para 48,
Huh?
last paragraph. Last portion. And para 50 also.
তারপর quote করে দিস। Of Balbir.
My lord,
Everything was quoted. All 20 paragraphs have been extracted from Balbir, put it in Anis
my lord,
by the same author.
my lord.
Yes, anything? And what is this?
Settlement, Nanak
Sukhar,
settlement.
Sukhar, a rule of Zesa. Oh. Regia. একটা রিসেন্ট রেজিস্ট্রেশন আছে এটা আমি প্যাকেটটা এই টেবিল ফোন যে আছে এই কালার যে টেবিল ফোন যে ফাইল থেকে আছে তাতে এটা প্যাকেট থেকে দুটা অপশন
Only 2 points. The prime witnesses are the family members of the accused person.
হুম
Although the deceased was also the in-laws, my lord's daughter-in-law, the other witnesses like the family members of the accused person, why they will lordship depose against the accused person, my lord? Why they should be disbelieved, my lord?
the defense tried to project that there was some enmity but
Enmity.
they were not successful perhaps only a plea.
My lord. And if your lordship considers the 164 statement of PW3, she is also have seen the occurrence, my lord, at
Hmm.
page 60. Fourth line.
Hmm. Res this year appears to be
Whether section 6 will be relevant or section 8 will be relevant.
No, both, my lord, section it conduct, because he was seen with the weapon of offense. And your lordship, other witnesses, immediately after the occurrence, they have witnessed the accused person standing near the dead body, near the victim. So it would come, your lordship. Evidence of PW3, lordship. While we were sleeping, we heard a cry, "Oi Morilu, I Morilu," whereupon we came out of the house and saw Reboti Lahon lying injured outside the accused house, and the accused moving there with a rod in his hand. Seeing us, the accused pelted stones at us. Then my husband and my son Soilen caught hold of the accused and tied him up. If your lordship considers the evidence of PW4,
Standards. Come to 106, 106. One zero six. 106 or, oh, sorry, I'm sorry, 6,
section 6.
6.
I know. Relevancy of
Ah.
facts.
Now come to illustration
Yes.
A.
Illustration A.
We'll pick up the words. A is accused of the murder of B by beating him. Okay, this fits the bill. Now, whatever was said or, we leave aside these words, said or. Whatever was done by A,
Accused, appellant,
A,
or victim.
we leave aside or B or the bystanders at the beating, right? Whatever was done by A or so shortly after it,
Before or after, yes, after.
after
Yeah,
it, we
yes.
are here after,
Yes, my
as to form
Part of the
part of
transaction.
the
part of the
transaction.
transaction is a relevant
Relevant
fact. I
While that I
think
was
that
holding
fits the bill. Wielding a
iron rod.
iron rod.
It should be immediately.
Immediately,
Immediately.
simultaneously.
Yes, I know.
Here it is a case, body lying
Yes,
and
I was standing.
commotion, hue and cry,
arrival of
immediate
the-
arrival of the witnesses, body lying at the doorstep in an injured condition, and the accused wielding an iron, whatever, in his hands beside him. So that will be part of the same
Same
transaction.
transaction.
I think
No, she's. My
This is the illustration.
lordship.
And whether anything comes under section 8,
Motive has
Eight
not
year-
been proved.
subsequent conduct.
Subsequent
conduct,
The conduct of
pelting stones,
pelting stones has not come properly. The conduct of any party to a proceeding, the conduct of any person, an offense against whom is the subject of any proceeding is relevant. If such conduct influences or influenced by any fact in issue or relevant fact, and whether it was previous or subsequent thereto. The conduct doesn't include statements, but those statements accompany explain acts are, but is used to affect the relevancy. Whether that conduct will come.
probably it
Conduct.
come.
How?
Lordship, because accused was standing with the weapon.
That comes under 6.
No, that is as regards, part of same transaction as regards the witnesses are concerned, my lord.
Hmm.
They have witnessed the occurrence, they have reached at the place of occurrence and witnessed the occurrence. So they become the part of the same transaction, my lord. But as regards the conduct of the accused person, the witnesses found the accused standing with a weapon of offense. And as per the evidence of PW4, my lord, when the accused tried to run away from the place of occurrence, I chased after him. The accused again came to the place of occurrence and again assaulted Reboti with an
That
iron.
part is not consistent with PW1 and PW3, we have already said. The second part of that trial court judgment, referring to 161,
Lordship.
that is also not
My
correct.
lord.
We have to tread carefully, otherwise merely making wholesome will be very difficult for us.
To my understanding, it will be related to motive and preparation, the conduct. In section 8 is relatable to motive and preparation.
No, Hari.
No.
এটা যে জাজমেন্ট দিছিলো এটা বৰ্মনে নে কি আছিল দোকানৰ সন্মুখত মাৰিছিল তাৰ দোকানৰ সন্মুখত মাৰি যে কোপটো মাৰি যে মানুহটো যে পলাই গৈছিল দাখন লৈ জাজমেন্টটো কোনোবা দোকান চাবৰ লগতে আছে নেকি? Yes, anything more?
That much.
No.
Well,
I think
then-
chain is complete. Or it may not be complete, but accused did not offer an explanation. And
Yes,
his-
that part, yes, we find that in Balbir Singh, I think I have marked somewhere. One part is that once the prosecution established a prima facie case,
My lord.
the appellant was obliged to furnish some explanation under section 313
Lordship.
with regard to the circumstances under which the deceased met an unnatural death inside the house. His failure to offer any explanation whatsoever therefore leaves no doubt for the conclusion of his being the assailant of the disease. That is 2019, explaining 106.
Yes.
One part in 1955, Devnandan Mishra. It is true that in a case of circumstantial evidence, not only should the various links in the chain of events be clearly established, but the completed chain must be such as to rule out a reasonable likelihood of the innocence of the accused. But in a case where the various links have been satisfactorily made out and the circumstances point to the accused as a probable assailant with reasonable definiteness and in proximity to the deceased as regards time and situation, and he offers no explanation, which, if accepted, though not proved, would afford a reasonable basis for a conclusion on the entire case consistent with his innocence. Such absence of explanation or false explanation would itself be an additional link which completes the chain. I think this
appears to be the correct
Not sure.
proposition. Because it is not, that body was at the doorstep. Body was at the doorstep, not inside a closed room with the accused. That is what something here or there makes a whole lot of difference for other cases. That is the
But
concern we have.
Accused didn't say he was not there.
Yes.
Yes.
No, it is not. I'm saying directly applying Trimukh
My lord.
will be a
Because it
dangerous thing.
Secret.
Dangerous thing. That
Yes.
is why I am actually assessing the situation. You cannot directly apply everything Trimukh
Lordship.
everywhere as a straitjacket formula. You have to find out that was rendered in a case of an incident within the four corners of the room and with the husband being the only inmate, right? Here the body was at the doorstep. Still he owed an explanation. That is what we are concerned with. ইয়াতে পোস্ট করুন একটা বুড়াম দেখি বুড়াম Blow. Yes, blow is there. Post conduct. Paragraph 18, paragraph, sorry, section 8. Section 8. Section 8 is there. Section 8. এইটো আছিলে এইটো পঢ়িলে গম পাম এইটো আছে ক'ৰবাত ৰাখিব লাগে post occurrence be a relevance from the standpoint of section 8. Yes, we'll resume at 2 and read it. A sale is made in this criminal appeal preferred from jail under section 383, Code of Criminal Procedure 1973, CRPC order code, prejudgment. An order dated 5/2/2018, passed by the Court of Learned Sessions Judge Hibahagar in Sessions case number 37 within bracket S bracket close of 2015. Full stop. In the trial,
of Sessions Case Number 737 SS of 2015. The accused appellant faced a charge of uxoricide, and at the end of the trial, the Court of Learned Sessions Judge Ibagar, finding the accused appellant guilty of murder under Section 300, Indian Penal Code, sentence him under Section 302, IPC to undergo rigorous imprisonment for life and to pay a fine of rupees 1,000, in default of payment of fine, to undergo simple imprisonment for another month. Full stop. Para. It was Sessions Case Number arising out of Halwating Police Station Case Number 145/2014. Para. The investigation into the case, Halwating Police Station Case Number so and so was launched on the basis of a first information report, FIR, received by the officer in charge, Halwating Police Station on 8/9/2014 from one Soilen Lahon as the informant. Post in the FIR, the informant had inter alia stated that at around 10 p.m. on 7/9/2014, his younger brother, Mohendra Lahon, that is the accused, had an altercation with his wife, Reboti Lahon, that is the deceased, over some family matters. Full stop. In the process, the accused hit his wife on head a number of times with a wrench, WRENCH, within bracket steel color, resulting in grievous injuries on the person of his wife. Full stop. The informant had stated that the Reboti Lahon was immediately taken to the hospital at Amguri by an 108 ambulance with the assistance of police for providing treatment there. Full stop. As the condition of Revati Lahon was found serious, she was, later on, admitted at Jorhat Government Hospital or GMCH or what? Was admitted in Jorhat Hospital, civil hospital.
Amguri Civil Hospital,
Amguri, then
and then to AMC, Assam Medical College.
to the admitted, full name, Jorhat. To a hospital in Jorhat as per the advice of the doctors. System. However, Revati Lahon succumbed to her injuries at around 4 a.m. Para. On receipt of the FIR, the officer in charge, Halwating Police Station, registered the same as Halwating Police Station case number 145/2014 for the offense under section 302, IPC on 8/9/2014 and entrusted the investigation of the case to one Robindra Hazarika, within bracket PW8, a sub-inspector of police attached to Halwating Police Station. Full stop. Para.
Jorhat Medical College, not Assam Medical. Jorhat Medical.
Jorhat Medical.
All the-
Hospital in Jorhat, I have said.
Even the postmortem report.
Just hospital in a hospital in Jorhat, right? It has emerged from the materials on record that prior to registration, prior to lodgement of the FIR in respect of the incident, there was a general diary entry general diary entry number 140, Halwating Police Station case number, general diary entry number 140, dated 7/9/2014. Which was registered on the basis of a telephonic information received at the police station, received from one Prabhat Gogoi, the Sorkari Gambura of Nalin. Full stop. At 10:15 PM on 7/9/2014. Full stop. It was pursuant to the General Diary entry number 140. The No, it was pursuant. Pursuant to the General Diary entry number 140, the officer in charge Halwading Police Station had directed Robindra Hazarika to go to the place of occurrence to take necessary steps. Full stop. It was on the basis of the said direction, Robindra Hazarika, the IO had visited the place of occurrence, that is the house of the accused and the deceased on 7/9/2000 for in the during in the not articulated everybody. Visited the place of occurrence, that is the so and so, at around 10:20 PM on 7/9/2014. Full stop. At the place of occurrence, the IO PW8 finding the accused found that the accused was already kept detained there, took him into custody. Full stop. One steel meter handle with blood stain was found at the place of occurrence, and the same was also seized by the IO by preparing a seizure list. Full stop. After the accused was taken into custody, he was taken to Amguri Hospital for providing treatment. Full stop. As in the meantime, the injured person, Revati Lahan, was taken to Amguri Civil Hospital for providing treatment, The IO visited the injured there. Full stop. As the condition of the injured, Revati Lahan was found serious. And she was not in a position to talk, speak. She was referred to the Jorhat Medical College and Hospital. Full stop. After providing preliminary treatment to the accused, the IO brought him to Halwa Ting Police Station. Full stop. The injured, Reboti Lahan, who was being treated in the JMCH, breathed her last in the meantime there. Full stop. On receiving the news of death of Reboti Lahan at around 5:15 a.m. on 8/9/2014, the IO proceeded to the place of occurrence for confirming the fact of death of Reboti Lahan. Full stop. At the place of occurrence, he prepared a sketch map of the PO and recorded statements of a number of witnesses there. Full stop. In the meantime, the inquest on the dead body of the deceased was conducted by the police personnel from Jorhat Police Station. Full stop. After the inquest proceeding, the postmortem examination on the dead body of the deceased was performed at the JMCH on 8/9/2014. During the course of investigation, the I forwarded the sent I sent the seized meter handle and a portion of blood mixed soil for to the Directorate of Forensic Science, Assam, Guwahati, for serological examination. Full stop. After collecting the postmortem examination report and the report of serological examination,
comma, the PW8. Lead HR sheet under section 173(2) CRPC. Wide charge sheet number 11 of 2015 on 30/01/2015, finding a privacy case well established against the accused under section 302 IPC. Full stop, para. ZR case number हो corresponding 1885/2014. Full stop. On submission of the charge sheet, comma, the Court of Learned Additional Chief Judicial Magistrate Hibohagar secured the appearance of the accused from jail custody on 17/3/2015. Full stop. Upon such appearance, comma, the accused was furnished with the copies in compliance of the procedure under section 207, comma, CRPC. Full stop. As the offense under section 302 IPC is exclusively triable by the Court of Sessions, comma, the Court of Learned Additional Chief Judicial Magistrate Hibohagar, by an order of commitment dated 17/3/2015, committed the case records of ZR case number 1885/2014 to the Court of Sessions. Full stop. A jail superintendent Shivsagar district was directed to produce the accused before the Court of Sessions on 31/3/2015, and the learned public prosecutor was accordingly notified. Full stop, para. On receipt of the case records of ZR case number 1885/2014, pursuant to the order of commitment dated 7/3/2015, comma, the Court of Sessions registered the same as Sessions case number 37 within bracket S of 2015. Full stop. After hearing the upon appearance of the accused before it, and after hearing the learned public prosecutor and the learned defense counsel, and upon perusal of the materials available in the in the record, comma, the learned Court of Sessions had initially, comma, on (2/5/2015)
comma, frame the following charge against the accused. The particulars, when the particulars of the charge were read over and explained to the accused, comma, the accused abjured guilt and claimed to be tried. Poster. It is pertinent to mention that subsequently, comma, at a subsequent time, at a subsequent subsequently, and prior to, at what stage?
The arguments are over before passing on the judgment.
After argument or
My lord, the arguments are page 32,
after?
6/1/2018 and 30/1/2018. The arguments were heard. On the same day, 30/1/2018.
After closure of evidence from the prosecution side, semicolon, examination of the accused under section 313. The charge was altered the trial court altered the trial court on 30/01/2018 altered the charge under page 7. I go to page 6 as well. ঠিক আছে? After the charge was reframed, comma, the learned trial court explained the charge, explained and read over the charge to the accused afresh. And the accused pleaded not guilty and claimed to be tried. Poster. When the learned trial court asked both the sides as to whether they would re-examine the witnesses who were already examined upon alteration of the charge, comma, the parties expressed their disinclination for re-examining the witnesses again. Poster. After hearing the submissions of the learned counsel for the parties, appraised, comma, the learned trial court proceeded to deliver the judgment and order on five to 2018, comma as mentioned here in above poster. Where we have heard Mr. B. Prasad, learned amicus curiae for the accused appellant, and MS B. Bhuya, learned senior counsel and additional public prosecutor assisted by MS M. Chakraborty, learned counsel for the respondent state. Full stop. Mr. Prasad, learned amicus curiae appearing for the accused appellant, has opened his argument by submitting that the case is based, case is not a one of direct evidence, but the case is based on circumstantial evidence. Full stop. He has submitted that none of the prosecution witnesses had witnessed any assault on the deceased by the accused. Full stop. He has further contended that the serological result of the serological examination test had not provided any link connecting the accused with the alleged homicidal death of his wife. First off. It is his contention that the prosecution side has failed to establish all the circumstances by credible evidence to complete the chain of circumstances to which would chain of circumstances to prove that unerringly that it was only the accused who was the perpetrator of the alleged crime. Full stop. Judgment. আপু ভাই
in view of failure on the part of the prosecution to establish a number of circumstances in the chain the accused was not cast with an obligation to provide an explanation to the other incriminating circumstances. That is your case. Full stop. Mr. Prasad has referred to the decision in Parubhai versus State of Maharashtra, reported in 2021, 18 SSC 353 to buttress his, in support of his such submissions. Full stop. Whereas, au contraire, MS Mia, learned additional public prosecutor appearing for the state, has submitted that in the case in hand, the prosecution has been able to prove all the incriminating circumstances by credible evidence to complete the chain of circumstances. Post of 7 except post of it is MS Bhuya has contended that all the circumstances which are possible to be established by the prosecution, had been established and in such fact situation, the onus shifted to the accused to provide a plausible explanation under Section 106, Evidence Act. Full stop. In the absence of any plausible explanation on the part of the accused, the same had provided an additional link post op. The presence of the accused and the place of occurrence wielding a এটা কৈছিল না সেইটো ওতে কনস্টেন্ট থাকিলে ভাল meter handle in his hands with his wife in a moribund state at the doorstep of his house is a clear pointer to the fact that it was the accused only and none other, who was the assailant.
Full stop. MS Bhuiyan has further contended that since the injury was on the vital part, was on a vital part, that is the head. The medical evidence has substantiated that the crime was murder under section 302 IPC. Full stop. As such, comma, submitting so, comma, the learned state council has contended that the judgment and order of conviction and sentence passed against the accused needs no interference. And appeal being bereft of any merits, comma, deserves dismissal. Full stop. We have given due consideration to the submissions of the learned counsel for the parties. Full stop. We have also gone through the evidence materials on record, including the testimonies of the prosecution witnesses and the documentary evidence led by the prosecution in the course of the trials, comma, as available in the case records of sessions case number so and so in original. Full stop. Oh, MS Bhuiyan. In support of MS Bhuiyan, no, the decisions in Balbir KSL Anis. The decisions in itu Anis to SCR report is example so SCR my suppose. The reliance has been placed in the decision in the decisions of Balbir Singh versus State of Uttarakhand, comma, reported in 2023 12 SCR 815 and Anis versus State Government of NCT, comma, reported in so and so. Wherein the principle was enshrined in section 106 Evidence Act has been elucidated. First para. Eight we have submission of the as mentioned above, as has been mentioned above, comma, whatever আছে না during the course of the trial, the prosecution side, in order to examined how many? 8 number of prosecution witnesses, namely 1, 2, 3, 4, 5, 6, 7, 8, page 53, page 53. Reported in to Anis 2024 6 SCR 164. Page 53 is 1, 2, 3, 4. And namely could be 1, 2, 3, 4, 8. And exhibited eleven number of documentary evidence, which were 1 to 11. First of the prosecution also exhibited handle meter handle. One meter handle as MET EXT 1. After closure of the closure of evidence from the prosecution side, the accused was examined under section 313 CRPC. By putting before him the incriminating materials appearing from the prosecution evidence against him. The plea of the accused was that of denial after hearing. Before turning to the before evaluation of the ocular testimonies as regards the incident, it appears we at first turn to the medical evidence, which the medical evidence are in the form of the testimony of the autopsy doctor, PW6, and the postmortem examination report, EXT 7. Subpara. PW in his testimony, PW 6, Dr. Nitu Kumar Gogoi
was, on 8/9/2014, was serving as an assistant professor, Department of Forensic Medicine, Jorhat Medical College and Hospital. Full stop. In his testimony, PW6 deposed to the effect that at around 12 p.m. on 8/9/2014, he performed post-mortem examination of the dead body of Reboti Lahon, in connection with Jorhat Medical College and Hospital, PP, ZD entry number 120, dated 8/9/2014. In place to quote us. In place to.
365.
That is, I think, 120, right? ZD entry 120, dated 8/9/2014. After being identified by EVC 775 Bidan Bhomik and Ananda Lahon, the father-in-law of the deceased, within brackets, PW4. Poster. PW6 deposed stated that on examination of the dead body, he found the following. He recorded his findings as under query, page 19. A to A. PW6 further stated that after the autopsy, in his opinion, he recorded that the cause of death of the disease was due to as a result of the head injury. Full stop. He found that all the injuries were antemortem and were caused by blunt weapon. And the death was homicidal in nature. Full stop. He further recorded that the approximate time since death was 4 to 8 hours. Full stop. He exhibited the PME report as EXT7, with his signature therein as EXT71. Full stop. He also identified the counter signature of Dr. K.C. Das, MD, Professor and HOD of Forensic Medicine, JMCH, in the PME report EXT7 as EXT72. Full stop. The meter handle. When the meter handle, met EXT1 was shown to PW6, he stated that the injuries sustained by the deceased could be caused by MET EXT1, Full stop. PW 6 had categorically stated that injury number 1 was a fatal injury which was sufficient to cause death of a person in ordinary course of nature. Full stop. In cross-examination, PW 6 stated that as he was not asked to examine the blood group of the deceased, he did not mention the blood group of the deceased in the PMA report EXC7. Para, subpara. The PMA report, in the PMA report exhibited as EXC7, it is mentioned that the postmortem examination of the dead body of the deceased was performed at 12:30 p.m. on 8/9/2014. The findings and opinion recorded in the PME report EXC7 had received concurrence, were concurred by Dr. K.C. Das, MD, Professor, HOD, Department of Forensic Medicine, JMCH, and Police Surgeon, Jorhat. With his endorsement to that effect. Full stop. Para. Subpara. Inquest to exhibit করেছে, inquest to exhibit করেছে 65. The inquest proceeding on the dead body of the deceased was conducted at around 8:30 a.m. on 8/9/2014 in the Jorhat Medical College and Hospital. By an executive, by Somiran Bora, Executive Magistrate, Roman and Circle Officer, Jorhat within bracket East, in presence of a number of witnesses, including Ananto Lahon, PW4, in reference to JMCH PP General Diary Entry Number 120, dated 8/9/2014. Full stop. As per the inquest report, EXC 6, which was exhibited by PW 4 and PW and IO, PW 8, there were injuries on the head and right hand of the deceased. Full stop. Para. From the testimonies of the autopsy doctor PW 6 and the postmortem examination report, and the postmortem examination report, PME report, EXC7, it has clearly emerged that it is established that the deceased sustained a number of injuries, including page 19, one lacerated injury of size 7 cm into 2 cm into scalp dip over the vertex of head. Full stop. The underneath the injury, there were depressed fractures of parietal bones and its adjacent areas were found confused. Full stop. As per the medical evidence, all the injuries were antemortem in nature and were caused by blunt weapon. Full stop. According to the medical evidence, the injury, the lacerated injury sustained on the head, sustained by the deceased on her head, was sufficient to cause death in the ordinary course of nature. Full stop. Such finding was not contested in any manner by the defense during the course of the trial. Full stop. That the deceased had sustained an injury on her head is also corroborated by the findings recorded in the inquest report EXT 6. Full stop. On evaluation of this evidence. It can be the only conclusion that can be reached is that the disease succumbed to the injuries sustained on her head. Full stop. Such kind of injury, the said injury was opined to be caused by a blunt weapon. Blunt weapon, নয়? PME report কি করেছে? Blunt weapon. Full stop. Blunt weapon. Page 20. Blunt weapon. When the meter handle, mat ext1, seized during the course of investigation, was shown to PW 6. He stated that the injuries sustained by the deceased could be caused by mat ext1. Full stop. Here, para 34 to, huh? A2, female appeal jail 10 of 2017, huh? Here, para 34.
para. Out of the remaining prosecution witnesses, comma, PW1, comma, PW2, comma, PW3 and PW4 are close relations of the accused. Full stop. PW1 is the father of the accused and the father-in-law of the deceased.
Elder. PW1.
Oh, PW1
Elder.
is the informant and the elder brother of the accused and brother-in-law of the deceased. Whereas PW2 is the wife of PW1. Full stop. PW3 is the mother of the accused and the mother-in-law of the deceased, whereas PW4 is the father of the accused and the mother-in-law of the deceased. Father-in-law of the deceased. Full stop. PW5 is the Sorkari Gambura. And PW7. PW7 is a closed door neighbor, right? Next door neighbor. Next door neighbor is a next door neighbor. Full stop. It has emerged from the materials, evidence stroke materials and record and is not disputed by the defense in any manner that the houses there were two houses, two separate houses in the same compound. Full stop. In one of the said two houses, comma, the accused and the deceased used to reside. Full stop. In the other house within the same compound, comma, PW1, comma, PW2, PW3 and PW4 used to reside. Full stop. Sketch map, sketch map, sketch map, sketch map. The houses, the house of PW7 is in close vicinity to the houses of the accused and the deceased and the houses of PW1 to PW4, as is evident from the sketch map of the PO.
EXT 8. Full stop. Para. PW1, Soilil Lahon. In his evidence in chief, deposed to the effect that the incident occurred 1 year earlier. Full stop. On the date of the incident, no, on as regards on no, here he deposed to the effect that on the date of the occurrence, while he was at his home, his house, he heard a commotion. In the house of the accused. And when he came out of the house, his house, hearing the commotion, he saw Reboti Lahon lying at the doorway. Doorstep. At the doorstep of the house of the accused. PW1 also saw the accused there with an iron-like rod in his hands. By the time he reached the place of occurrence, his father, Ananda Lahon, PW4, also reached there. Full stop. On flashing the torch, they found the accused holding the rod and noticed bleeding injuries on the person of Reboti Lahon. Full stop. Thereafter, 108 ambulance service was called for taking Reboti Lahon to the hospital at Amguri. PW1 stated that the injured was taken to Amguri hospital at first, to the hospital at Amguri at first, and thereafter, to the Jorhat Medical College and Hospital, where Reboti Lahon breathed her last at around 6 p.m. 6 a.m. PW1 further stated that it was the VDP secretary who telephonically informed at the police station So accordingly, police personnel arrived at the place of occurrence and arrested the accused. Apart from seizing the rod used in the occurrence. PW1 exhibited the seizure list comma, MR number 48 stroke 2018. With his signature therein as EXT21. Poster. PW1 also identified the rod seized by EXT2, comma, as MAT EXT1 poster, stating that he lodged the FIR, comma, PW1 exhibited the FIR as EXT1 with his signature therein as EXT11. Poster. PW1 also identified the signature of the scribe of the FIR as EXT11. Poster. PW1 further stated that the rod was seized by police on being shown by the accused. Poster. In cross-examination, comma, PW1 admitted that he did not witness how the incident took place. Poster. PW1 further stated that the seizure of MAT EXT was made by police. Seizure of MAT EXT 1, iron rod was made by police from the house of the accused and not from the hands of the accused. Poster. PW1 denied the suggestions put to him by the defense. Poster. PW2, comma, Purabi Lahon. Like PW1, comma, deposed to the effect that on the night she was at her home during the night on 7/9/2014 when she heard a commotion in the house of the accused, comma, adjacent to their house. Poster. Hearing commotion, when she came out, she saw Reboti Lahon lying injured in the courtyard of the house of the accused. And the accused with an iron rod in her hands. Poster. PW2 further stated that police personnel arrived at the place of occurrence and arrested the accused. Poster. Though Reboti Lahon was taken to hospital, Jorhat Medical College Hospital, she breathed her last there. Poster. PW2 further stated that the rod was seized by police by EXT by the seizure list, comma, EXT2, wherein she gave her signature as EXT23. Poster. PW2 also identified the meter handle as MAT EXT1.
Poster. PW3 also stated that she gave her statement earlier before the court and she exhibited the such statement as EXT 3 with her signatures. Poster. এই আগত যে আছিল ন Reboti Lahon lying injured with bleeding injuries on her head. Huh? In cross-examination, PW2 like PW1, admitted that she did not notice, she did not witness how the occurrence took place. Full stop. PW2 also stated that at the time of occurrence, it was dark at the time of occurrence. At the time of occurrence, it was dark. Full stop. PW2 denied all the suggestions given to her by the defense. Full stop. Para. PW3 in her testimony, PW3 deposed to the effect that it was at around 10:30 p.m. on the night about 2 years earlier, she no when did while she, her husband PW4, her son, PW1, and her daughter-in-law PW2 were sleeping in their house. They heard a cry, Oi Morilu, I am dying, from the house of the accused. And hearing the cry, they came out of the house and saw Reboti Lahon lying injured outside the house of the accused. With the accused with an iron rod in his hands. Then, her husband PW4 and her son, then her husband, like PW1 and PW4 caught hold of the accused and tied him up. The villagers also gathered at the place of occurrence. Lying injured with an injury outside the house of the accused, being injured with an injury on her head. When Reboti Lahon was taken to the Jorhat Medical College and Hospital, she expired there at around 2:30 a.m.
PW3 further stated that police personnel came and examined her. Full stop. Police also seized the iron rod found in the hands of the accused. By seizure list, ext 2, wherein she gave her signature as ext24. Full stop. PW3 also identified the iron rod seized by the seizure list ext2 as MAT ext1. Full stop. PW3 also stated that she gave her statement earlier before the court and exhibited the statement as ext4, which her signatures therein. Full stop. In cross-examination, PW3 stated that she did not see the accused assaulting his wife. Full stop. PW3 also stated that it was 5 years earlier, the accused. It was from 5 years earlier, the accused started living separately from them. PW3 claimed ignorance as to whether the accused had committed the incident with MAT ext, with iron rod, MAT ext1. Full stop. Para. PW4, Ananda Lahan, testified that it was about 5 years since when the accused started living in a separate house, adjacent to their house. Full stop. On the incident, PW4 deposed to the effect that at around on that night, at around 10:30 p.m. On that night, about 2 years ago, at around 10 p.m. day, that's he, his wife, PW3. Day বুলি ক'লে dash দি পেলাই PW1, PW no, day. Dash he, his wife, PW3, and his son, PW1, who were sleeping in their house. Full stop. Then they heard a cry, Morilu, I am dying. PW4 আছে হ্যাঁ চাই ল'ব। They immediately came out of the house and saw Reboti Lahan lying injured outside the house of the accused. Full stop. PW4 further stated that when the accused then made an attempt to run from the place of occurrence and he chased him. Full stop. Then, the accused again came to the place of occurrence and assaulted Reboti Lahan with an iron rod. Full stop. PW4 further stated that when he tried to prevent the accused from assaulting Reboti Lahan, he was also threatened. Poster. PW4 further stated that thereafter, he and his son, PW1 caught hold of the accused and tied him up. Poster. PW4 stated that Reboti Lahon, the injured, was taken to the medical college at Jorhat by a vehicle, but at around 2:30 a.m., Reboti Lahon expired there. Poster. PW4 also stated that he gave his statement earlier in the court and exhibited his such statement as EXT5 with his signatures therein. Poster. PW or the iron rod met EXT was identified by him during his testimony. Poster. PW4 stated that in the inquest report, EXT6, he gave his signature. Poster. During cross-examination, a number of suggestions were given to PW4, but all those suggestions were denied by him. Poster. The previous statement of PW4 the defense had not, however, confronted PW4 with his previous police statement. In order to bring out contradiction by putting such statement subsequently before the IO, who was examined as PW 8. Poster. When PW6 stated that it was he who handed over the seized iron rod to police, it was found to be objected by the defense. Poster. PW4 also further stated that the accused started living separately after a quarrel with him. Post-op. It was elicited from PW6 by the defense that he did not like the accused due to the quarrelsome nature of the accused. Post-op. PW denied had however categorically denied that he had adduced false evidence against the accused because he disliked the accused. Post-op. From the testimonies of the above prosecution witnesses, comma, it has been established that on the night of the incident, comma, the prosecution witnesses, that's PW1, PW2, PW3, and PW4, were in their house together. In their house together. Full stop. When they were in their house, comma, they heard a commotion. Heard a commotion, a commotion. Heard a commotion. From the from the house of the accused and the deceased. Full stop. PW2 PW3 and PW4 both PW2, 3 and PW4 testified that the cry was to the effect that, quote unquote, I am dying. Poster. All these prosecution witnesses, PW1 to PW4, had stated that, had testified that they reached the place of occurrence immediately after hearing the cry. Poster. It needs a mention again. It needs a mention, comma, at the cost of repetition, comma, that
the house of the accused and the deceased was in was in close proximity, no? Was adjacent to their house and within the same compound. Poster. It has also been established from the testimonies of PW1 to PW4 that going at the place of offense, at the PO, comma, they found Reboti Lahan lying at the doorstep and outside doorstep of the house of the accused and the in an injured condition and the accused was also, they found the presence of accused also beside the injured with an iron rod in his hand, iron like rod. Full stop. The testimonies of these prosecution witnesses on the above points were not confronted by the defense when they were cross-examined. Full stop. Para. Learned amicus curiae has raised a contention to the effect that the description of the alleged weapon of assault were given differently by different witnesses. Full stop. He submitted that in the FIR, ext 1, it was mentioned as a wrench within brackets steel color. Yeah. Steel color. Full stop. In the charge framed against the accused, it was mentioned as an iron pipe. Full stop. Full stop. PW one stated the same as an iron pipe-like weapon. Iron pipe-like weapon. At one place. And stated and mentioned as a rod at another place during his testimony. Full stop. PW2 described the alleged weapon of assault mentioned it as an iron rod. Full stop. According to PW3, it was an iron rod. According to 3 and 4, niki? According to both 3 and 4, it was an iron rod. Full stop. As per the seizure list, MR number 48/2014, a meter handle. Yardstick কি বস্তু? Yardstick তো এটার meaning নহয়, এটার কোনো meaning নেই। এই টাইপ করছে সব আসল তো সব। Handle type seizure to what assault? Assault to পালে গম পাম। খবর ইংলিশ বেলেগ হয় ন? Translation sometimes creates havoc. So let us have.
Time is not mentioned there. It is
Huh?
list, it is, time is not mentioned. But in his evidence, it is there.
No, what is the exact description?
Yardstick.
It might be translated. Let us see. Who does the seizure? Seizure to given EXT? True. Speak truth. This yardstick
Yardstick.
has been added by the translator from his or her side. There is nothing. 1 meter handle. Within bracket, steel color of 2 feet length was seized.
Here he added 9-inch.
Did, huh?
9-inch was added.
Which one?
That be brought by 9-inch.
We're not going into that.
It is because of that encryption was the torque meter. It is a rod, range type rod, torque meter.
Gusto. From the different, the witnesses. Though the witnesses prosecutor, no, আরোটা আছিল নহয়, আরোটা আছিল ক'ৰবাত। এটা আছিল ন? আর কোনো কোশ্চেন নাই কোনো? কি কৈছে ই?
Who does an iron engine? Our police sees the handle in my police.
Okay.
Seven. 782.
Notwithstanding the
Then it will get this.
the
Described differently, but it probably means the same thing.
মানে notwithstanding the discrepancy discrepancy নহয় এটা মানে description notwithstanding the differences notwithstanding notwithstanding the manner of notwithstanding the different manners of description of the alleged weapon of assault, comma, we find from the testimonies of the prosecution witnesses that prosecution witnesses, comma, PW1, PW2, and PW3 and PW4, that they in their testimonies, comma, were consistent on the point that they the material the MET EXT1 was and the meter handle or iron rod as they describe differently, comma, is one and the same. Is one and the same. Corroboration from full stop. Who is one and the same. Full stop. Para. The five.
Page.
PW5, comma, Prabhat Gogoi. Who is the Sarkari Gambura, comma, testified to the fact that on the date of the incident, comma, which was about 2 years earlier, comma, he at around 7:30 PM stroke 8 PM, comma, proceeded to the house of the deceased on hearing commotion from there. Full stop. As his house was adjacent to the house of the accused, he going there saw Reboti Lahan lying in an injured condition with bleeding injuries on her head in a courtyard of the house of the accused. Full stop. PW7, who is also a next door neighbor, testified that at around 8:30 p.m. on 7/9/2014, hearing hue and cry at the residence of the accused. Went there and saw the wife of the accused, Reboti Lahan, lying in an injured condition with bleeding injuries in the courtyard of the house of the accused. Full stop. PW5 further stated that he, in his capacity as Sorkari Gaumura village admin, informed the incident to at the police station, and his such testimony stands corroborated by the Halwating Police Station General Diary entry number 140 dated 7/9/2018 within bracket EXT 11, and the testimony of the IO, PW8, who stated that it was after being informed by the Gaumura, police personnel proceeded to the place of occurrence on 7/9/2014. Full stop. The fact that accused was kept tied in the courtyard and he was arrested by police after their arrival at the PO is found mentioned in the testimony of PW5. Full stop. Both PW. I don't know, one I know, PW 7. PW 5 was also a witness to the seizure list, ext 2, whereby the iron, whereby the meter handle was seized. Poster. PW 5 also identified the meter handle seized by the seizure list ext 2 as met ext 1. Poster. The testimonies of the two witnesses, PW 5 and PW 7 had lended corroboration to the testimonies of PW 1, PW 2, 3, and 4. And their and are not inconsistent in any manner. Lended corroboration and are not inconsistent with the testimonies of PW 1 to PW and Mazhabji Pillai last for PW. Poster. Para. When accused CIBC. Report was 313 থাকিব পাৰে নেকি? এটা ঘৰত আছে নেকি 313? 313 313 পৰা থাকিব পাৰে এটা চাওকচোন। এই যে ইউজ কৰিব পাৰি যে the prosecution witnesses, PW 1 to 4 had emphatically asserted that the accused and the deceased used to being husband and wife, used to reside in a separate house. Used to reside together in a separate house. The prosecution witnesses PW 1 to PW 4, in their testimonies, did not mention about presence of any other person in the place of occurrence, other than the accused, with the iron meter in hand. Iron meter as well. Iron meter. A meter handle. Meter handle. It is very difficult to stop. Sheet 13. 313, huh? 313 of the herit level, the married level.
Can be looked to.
It will. আমরা এটা SSL থেকে একটা SSL মানে one এ। E13. Yes, any idea? 313 can be explained and can be taken into consideration. Huh?
Or incriminating circumstances has to be put to the.
Right, no. That answer given by
Can you just?
the accused during 313 examination it can also be taken as lending corroboration to the case of the prosecution.
Surya, can you ask your junior to find out the citation 2010, volume 7 SSC 759?
Eight.
I'm not having Wi-Fi in that.
What is the new one?
2010, volume 7 SSC 759.
Lordship, but there is a citation to that effect. If he gives the wrong answer, then it will give
No, that
additional,
is
yes.
different here.
But
Whether yes, I'm looking. at-
No, madam. নহয় মোৰ তাতে এইবিলাক নাই এনেকে ফ্লিপ পৰা মাৰা আছে 313 বুলি লিখা আছে এটা বিচাৰি থাকিব তাৰপিছত নাপায়
Volume 7 SSC 759.
জানো এটা যত মাতক
We got it.
ক্লিক মাৰা আছিল সৰুকে এনেকে ক্লিক মাৰা আছিল
759.
মাৰা থাকোতে ইয়াতে এনেকে 313 বুলি লিখা আছিল
28.
আছেনে নাই হ'ব 313 বুলি লিখি ৰাখক 313 বুলি লিখি ৰাখক হা ডাঙৰকে নাই পোৱা আছে মোৰ তাত আছে তেওঁলোকে বিচাৰি পোৱা নাই বেচিকেলি the objective it can be used forward কৰিব পাৰি when accused was examined under section 313, CRPC, he admitted that he and his wife, the deceased, used to live in a separate house near to the house of PW1 to PW4. Near to the house wherein PW1 and PW2 PW4 used to live. Full stop. Clara.
one paragraph I have got that judgment cited in motion. Following the law.
The prosecution
I'm sorry.
in this case, on a thorough on appreciation of the above evidence of the above of the evidence stroke materials on record, as discussed above, we find that the prosecution has been able to prove the fact that the accused and the deceased, who were the husband and wife, used to live in a separate house adjacent to the house of the adjacent to the house wherein the prosecution witnesses PW1 to PW4, used to reside within but in the same compound, full stop. At the when the prosecution witnesses PW1 to PW4 reached the place of occurrence in close proximity of time, the accused was found wielding met EXT1 in his hand with his wife lying on the doorstep of his house in a moribund state with bleeding injuries on her head. Poster. It has been further proved that the met এটা কি করে? meter handle, met ext, which was found in the hand of the accused at the time was the one which was seized by the IO by the seizure list, EXT2 on the from the PO on what is the date of seizure list? EXT2 on 7/9/2014. In reference to Halwating Police Station, case number General Diary entry number 140, dated 7/9/2014, in presence of witnesses. Full stop. The autopsy doctor, PW6, deposed to the effect that the injuries, more particularly, the injury number 1, lacerated injury KSL, that's scalp tip, could be caused by met EXT1. Full stop. As per the results of the serological test, contained in EXT9, met EXT contained blood stain. Soil to core in view of such overwhelming evidence,
we find that the learned additional public prosecutor is right in her contention that the prosecution has been able to prove all the circumstances by evidence of conclusive nature, which in the facts and circumstances obtaining the case, were possible on the part of the prosecution. And as a result, the onus shifted to the accused to provide a plausible explanation at least by the preponderance of probabilities to teachers to teachers it to teachers the onus which has fallen on him. First of para. Dolby ne kiya Gita? Anis. Before going at this juncture, it is yeah, 34 too. 34 ক'ত কৈছো ন নে পিছত কম বুলি কৈছিলো 34 টো পেৰা 34 যে এইটো জাজমেন্টৰ এইটো মূল জাজমেন্টৰ আগত কৈছিলো নেকি হা আগত কৈছো হা Yes. Which part we find that no, it lasted খালি প্যারাগুলো লিখিত হয়ে যাবে সলভ হয়ে যেতে আর we find that the decision in Parubhai, referred to by learned amicus curiae, is not of any assistance to the case of the accused appellant, as the facts and circumstances obtaining in Parubhai are different from the facts and circumstances obtaining in the case in hand. Full stop. In Parubhai Supra,
the appellant was charged with the offense of killing the first wife of her husband. Full stop. The facts, briefly stated, the facts, in brief, were that in the night intervening 2/8/2006 stroke 3/8/2006 at about 2:30 to 3 a.m., an incident of fire occurred. And the house in which the appellant and the family members were residing was engulfed in flames. The appellant managed to come out of the house unscathed, while the first wife of her husband and their daughter rushed out of the house with burn injuries, while the son of the first wife got burned to death inside the house. First off. It was in such backdrop, the court, Honorable Supreme Court has observed that if in the middle of the night, for whatever reason, there was fire, and if the appellant had woken up and noticed it a little earlier, the natural conduct is to run out of the house instead of going into the house, which is burning, to check on the other inmates. Full stop. It takes a person a lot of courage or be overdriven with compassion to get back into the house to save somebody else, and not doing so may be considered as morally wrong for not coming to the aid of fellow human being in distress. But it cannot be a circumstance to hold a person guilty of a crime which is as serious as murder, unless the other circumstances in the chain point to the accused so as to lead to an irresistible conclusion of being guilty. Full stop. The first wife of the husband of the appellant, who came out alive and lived for a day, did not blame or suspect anybody, including the appellant. Full stop. The court on analysis of the evidence on record
found no overt act of indulgence on the part of the appellant, no other overt act. Full stop. It was in such facts and circumstances, comma, the decision in Parubhai was judgment in Parubhai was rendered. Full stop. এইটো পিছৰ পেৰাগ্ৰাফত সোমাব লাগিব, খালি মই ডিক্টেশ্যনটো দি থলো হা। Para. Submission. One zero six কি আছিল বা wordটো কমপ্লেইনটো 106 or according to make the fabulous. One zero six ইয়াতে আছে 106 এটা 106 টো দিব লাগিল ন Uh, 106 বলবিটো আছিল ন বলবি আৰু আনিছ না it is true that no, it is right that one zero one what question is asking 101 right that under section 101 of the Evidence Act, comma, whoever desires any court to give a judgment as to a liability dependent on the existence of facts, comma, he must prove that those facts exist. Full stop. Therefore, comma, the burden is always on the prosecution to bring home the guilt of the accused beyond a reasonable doubt. Full stop. Section 106 of the Evidence Act is an exception to Section 101. Full stop. Section 106 of the Evidence Act will apply to those cases where the prosecution has succeeded in establishing the facts from which a reasonable inference can be drawn regarding the existence of certain other facts which are within the special knowledge of the accused. Full stop. When the accused fails to offer proper explanation about the existence of the said facts, comma, the court can always draw an appropriate inference. Full stop. উঠে দিও নি কেন? উঠে দিও নি না লাগে in Trimukh Maruti Kirkan versus State of Maharashtra, reported in 2016 SSC 681, the Honorable Supreme Court. While considering a case of homicidal death in the confines of a house, has observed that the law does not enjoin a duty on the prosecution to lead evidence of such character, which is almost impossible to be laid, or at any rate, extremely difficult to be laid, LED. The duty on the prosecution is to lead such evidence which it is capable of leading, having regard to the facts and circumstances of the case. It has been observed therein that where an accused is alleged to have committed the murder of his wife, and the prosecution succeeds in leading evidence to show that shortly before the commission of the crime, they were seen together, or the offense takes place in a dwelling house where the husband also normally resided. It has been consistently held that if the accused does not offer any explanation how the wife received injuries, or offers an explanation which is found to be false, it is a strong circumstances which indicates that he is responsible for the commission of the crime. Full stop. পিকচারটা ফটোগ্রাফ বলবীর না বলবীর হাতে দাগ মারিছিল মানে দাগটা মারিছিল তো ভাই খুব জোর ওই 1955 এর ওটা আছে 1955 যে করেছিল in Balbir Singh versus State of Uttarakhand, Supra and Anis versus State of Government of NCT, Supra. The Honorable Supreme Court has considered has explained no, has considered a case a prima facie case. হল নাকি? হয়ে যাবে। Prima facie case in the context of section 106 of the Evidence Act. Full stop. আরো 5 মিনিট বেশি। Section, it has been held that section 106 of the Evidence Act would apply to cases where the prosecution could be said to have succeeded in proving facts from which a reasonable inference can be drawn regarding it. Post. Para. In Devnandan Mishra versus State of Bihar, reported in AR 1955 Supreme Court 801. The Honorable Supreme Court has observed as under, it is true that in a case of circumstantial evidence, not only should the various links in the chain of circumstances be clearly established, but the completed chain must be such as to rule out a reasonable likelihood of the innocence of the accused. But in a case where the various links have been satisfactorily made out and the circumstances point to the accused as the probable assailant, with reasonable definiteness and in proximity to the accused as regards time and situation, and he offers no explanation, which, if accepted, though not proved, would afford a reasonable basis for a conclusion on the entire case consistent with his innocence. Such absence of explanation or false explanation would itself be an additional link which completes the scene. Full stop. Para. In the reverting back to the facts of the case, we have already indicated about the we have already discussed about the facts established by the prosecution by leading evidence of conclusive nature. Full stop. As the accused was found in the company of his wife. Who was in a seriously injured condition. In close proximity of time from the assault, which was found to be fatal assault, comma, the accused clearly owed an explanation as as regards the circumstance in which his wife sustained such fatal assault. Full stop. Seven except full stop now again. From the nature of suggestions, made to the prosecution witnesses, we find that apart from not providing any explanation anywhere, including at the stage of his examination under section 313 CRPC, the accused did not raise any kind of defense pleas so as to displace the notion that he was not the probable assailant. আর ওটা মার্ডার হলে এটা মার্ডার প্যারা in the face of such, in the light of the in a backdrop of such evidence to materials on record, comma. Yes, that's serial. Fine, দেখি লোক একটু আমার অফিসিয়াল কি করবো এটা in the absence of any explanation, not to speak of plausible explanation, comma, the it is to be. It is the logical the the only logical inference that can be drawn is that it was the accused alone who, with the object of assault, comma, mat ext1, inflicted the injuries on the person of the deceased, comma, as reported in the PMA report ext 6 7 and the and the and amongst the injuries sustained by the deceased, comma, the injury, the accused aimed the injury aimed one blow at a vital part of the disease, comma, the head. Full stop. There is no evidence to draw any inference that there was no evidence to bring the case in hand within one of the exceptions to section 300, comma, IPC. Full stop. In the above facts and circumstances, in the face of above established, in the above proved circumstances, comma, it is apt to refer to the following observations made in Jagrup Singh versus State of Haryana, comma, reported in 1981, comma, 3 SCC 616, comma, which are made following the ratio laid down in Virsa Singh versus KSS High Level, AIR 1958 SC 465
State of Punjab.
or State of Punjab, which explain the applicability of clause thirdly of section 300 IPC, quote unquote, paragraph 6. There is no justification for the assertion that the giving of a solitary blow on a vital part of the body resulting the death must always necessarily reduce the offense to culpable homicide, not amounting to murder punishable under section 304, part 2 of the code. If a man deliberately strikes another on the head with a heavy log of wood or an iron rod or even a lathi, so as to cause a fracture of the skull, he must, in the absence of any circumstances negativing the presumption, be deemed to have intended to cause the death of the victim or such bodily injury as is sufficient to cause death. Full stop. The whole thing depends upon the intention to cause death, and the cause may be covered by either clause firstly or clause thirdly. The nature of intention must be gathered from the kind of weapon used, the part of the body hit, the amount of force employed, and the circumstances attendant upon the death. Full stop. In such para, in the light of the discussion made above, and for the reasons assigned therein, we find no reason to interfere with the judgment findings reached by the learned trial court in its judgment and order dated so and so. Full stop. As the accused is found to be guilty of the offense of uxoricide, we affirming the judgment and order of conviction and sentence passed by the learned trial court. We affirm, affirming, dismiss. How we affirming, while affirming the judgment, so and so, finding no merits in the present appeal, dismiss the appeal. Mm. 8313 এইটো ৰাখি থবচোন সিদিনাখন আমি এইটোত আছিলো নেকি এইটো থৈ দিব 313 কাৰণে মই পিছত তাৰপৰা কৈ দিম
Lordship,
yes
legal services authority to be directed.
Appreciation, send back the case record. No, this 106 is difficult where it will be activated, where it will not be activated. Yes, Mr. Munir. Anything.
Item number 6, man. I pray.
Detention, how much?
2 years and 6 months. And can I pray for a date, madam?
No date then. It will come by, we can say that after a week. We can say
The
that.
previous order
Otherwise-
was like, listed, the previous order, madam, that was to be listed in the next week, but it came up after 2 months, madam. That is,
And then we have no other option. We have no other
praying for a
option.
date, madam. Let me.
We can
day after
only
next.
say that stands pass over for the day. Or let it remain like this.
Madam?
Left over.
Left.
Whatever you want to,
I only wanted that.
we accept fixed date, you ask for anything. You can ask for anything.
I am equipped with other things, man.
Left over. Good enough.